Oh. Beep beep boop. Beep beep boop. DJ, spin that shit! All right, everybody! Time to go, time to go. Welcome to Conflicts of Laws. Welcome to Choosing Legal Regimes. We are nearing the end of the semester. This is the end of the book. We got 3 exciting-ish cases for y'all today. We got a green highlighter to mark them up. The first case for today is Brewer versus Missouri Title Loans. So here we go. Setting it up. 2012 case. This is those title loan companies that were going out there and saying like, hey, give a title to your car, and they're charging like 45% interest rates. So, a little backstory. Here's how we go. Oh my God, you can't make this crap up. The judge writing the opinion in Brewer versus Missouri Title Loans name is Titleman, the Chief Justice of the court. You cannot make this crap up. All right, here we go. Missouri Title Loans Incorporated appeals a judgment finding that a clause arbitration waiver contained in its loan agreement, promissory note, and security agreement is unenforceable. In Brewer v. Missouri Title Loans from 2010, 2 years prior to this decision, right, the court affirmed the judgment insofar as it held that the class arbitration waiver is unconscionable and reversed that part of the judgment, ordering that the claim be submitted to an arbitrator to determine the suitability for class arbitration. The court held that the appropriate remedy was to strike the entire arbitration agreement. The United States Supreme Court then vacated, means something goes up on certiorari to the Supreme Court, they vacate saying, no good, go down back. The United States Supreme Court vacated Brewer and Missouri Title Loans Incorporated in 2011 and remanded the case to this court for further consideration in light of the Supreme Court's decision in AT&T versus T-Mobile. Applying the T-Mobile case, the court finds that the presence and enforcement of the class arbitration waiver does not make the arbitration clause unconscionable. So unconscionability real quick, right? Unconscionability is something when you're going to enter into a contract, right, that somehow by diminished mental capacity, by being forced, by being threatened, by being somehow not in your right mind, or being also like, if, okay, so say that you were making a contract with a guy who sells motorcycles. Like he's a motorcycle manufacturer and seller, right? And this is your first time even touching a motorcycle, right? That would be what's called the sophistication of the parties. This is your first time doing a contract regarding motorcycles. This guy's been doing motorcycles for 20 years, right? The sophistication of the parties could also be determined to be part of the analysis for unconscionability. Basically, unconscionability means that the contract you entered into was somehow perverted on one side so that it couldn't have been properly entered into by the other party, right? All right. Back to the case at hand. The court finds the court finds the presence and enforcement of the class arbitration waiver does not make it unconscionable. This court instead applies traditional Missouri contract law in looking for the agreement as a whole to determine the conscionability, which is the opposite of unconscionability, right, of the arbitration provision. This court holds that Brewer has demonstrated unconscionability in the formation of this agreement. The appropriate remedy is the revocation of the arbitration clause contained in the agreement. Consequently, the judgment is affirmed in part and reversed in part, and the case is remanded in part. Facts. Beverly Brewer borrowed $2,215, right, from the title company. The loan was secured by the title to Brewer's automobile. The annual percentage rate on the loan, the APR on the loan, was 300% APR. The agreement provided that Brewer must resolve any claim against the title company in binding individual arbitration governed by the Federal Arbitration Act, FAA, or the Act. No customer ever successfully has renegotiated the terms of the contract, including the arbitration provisions. Although the agreement provided that Brewer waived her right to litigate a dispute in court, the title company specifically retained its right to, quote, seek possession of the collateral in the event of default by judicial or other processes, including self-help repossession. So self-help repossession means Dog the Bounty Hunter. It means ninjas in the night coming for your crap that you put as collateral for your loans, right? In other words, the title company may utilize the courts to repossess the customer's vehicle, but the customer cannot go to the courts to renegotiate its contract. They have to go to arbitration. Arbitration doesn't go well for anybody who knows, right? To complain about violations to the customer's rights under the contract terms. In addition, the agreement stated, quote, the parties agreed to be responsible for their own expenses, including all fees for attorneys, experts, and witnesses. Unlike some arbitration contracts, such as the contract at issue in Concepcion previous case, the agreement did not provide an attorney fee multiplier or guaranteed minimum recovery if the consumer is awarded more than the title company's last offer during the arbitration. The arbitration contract in Concepcion provided that a customer who is awarded more than AT&T, so this is the AT&T T-Mobile case, right, is entitled to a minimum recovery of $7,500 and to double that for the attorney's fees, okay? The cumulative real-world effect of the arbitration provision of this case is that the consumer's minimum and maximum recovery from the title companies are identical, which is $0. No consumer has ever filed an individual claim for arbitration against a title company. Woof. Brewer made 2 payments to the title company of more than $1,000, but the payment only reduced her loan principal by 6 cents. Okay, so she, oh my good Lord. This woman took out a title loan for a car for $2,215. The APR on that loan was 300%. She made 3 over $1,000 payments to the loan company. And after she made those three monthly $1,000 payments for the loan of $2,200, the entire balance on her loan was lowered by 6 cents. Not 6%, 6 cents. Brewer then filed a class action lawsuit petition against the title company alleging violations of numerous statutes, including the State Merchandising Protections Act. The title company filed a motion to dismiss or stay the claims and to compel Brewer to arbitrate her claims individually. And this is in brackets by the court. At issue on remand is whether the arbitration clause or class waiver are unenforceable because of unconscionability. On remand, the title company asserts that FAA, the Federal Arbitration Act, wholly preempts Missouri's common law of unconscionability. Alternatively, the title company asserts that the availability of a statutory attorney's fees negates Brewer's unconscionability defense. So there's a statute this is what the title company is arguing. There's a statute that says that you get attorney's fees. So because there's a statute that says that, you can't argue unconscionability. Let's see where this goes, people. On remand, the title company, because the fee provisions make it possible for consumers with small dollar amounts to claim counsel. Before addressing the title company's argument, this court must first address the law that was established in Concepcion. So now the analysis goes to AT&T versus Concepcion. Determining the law established by Concepcion is complicated. Concepcion, God, why do I keep having to say Concepcion every 4 seconds? Good Lord. is best understood by considering Justice Scalia's majority opinion as further informed by Justice Thomas's concurring opinion. Both opinions, for slightly different reasons, stand for the proposition that the Act generally does not permit a state to bar class action waivers by finding that an arbitration agreement unconscionable on the basis of a class action waiver alone. The Scalia opinion does not state, however, that the Federal Act otherwise preempts traditional state law defenses to contract formation, which includes unconscionability, duress, and fraud. And Justice Thomas is clear that he would apply those defenses: duress, unconscionability, and fraud. But Concepcion, again, teaches that these defenses cannot be used in a way that would hold otherwise valid arbitration agreements unenforceable for the sole reason they bar a class action lawsuit and class action form of relief. In Concepcion, there it is again, the plaintiffs filed a class action lawsuit alleging in part that AT&T engaged in false advertising and fraud by charging sales tax on the phones it had advertised as free. Free iPhone, free iPhone, free Samsung Galaxy. But we're going to charge you sales tax on zero. The district court specifically found the arbitration agreement was quick, easy to use, and likely to promptly fulfill or even excess payment of the customer without the need to arbitrate or litigate. The district court also found that the provision of a, quote, $75,000 premium in the event that the consumer was, $7,500 premium in the event the consumer was awarded more than AT&T's final written settlement offer served as substantial inducement for the consumer to pursue individual arbitration as opposed to class arbitration. So are you going to make a class action lawsuit, or are you going to do an individual lawsuit? If you do an individual lawsuit, we have something in a contract that says you get more money already, automatically, right? All right. Although individual arbitration was more beneficial to a consumer than class arbitration, the district court held that the arbitration provision was unconscionable under California Supreme Court's decision in the Discover Bank case. Given the factual context, the question framed by the Scalia opinion is whether Section 2 of the Federal Arbitration Act preempts California's rule classifying most collective arbitration waivers in consumer contracts as unconscionable. The Discover Bank decision, the California decision, right, held that a class action waiver in a consumer contract of adhesion is unconscionable when the consumer claims against the defendant are predictably small and the plaintiff alleges a scheme to cheat consumers. Notably absent from the formulation of the Discover Bank ruling is any finding that the consumer is worse off under individual arbitration than he would be under a class action arbitration, or that the individual terms of the arbitration agreement are otherwise onerous or unfair or unconscionable. The practical effects of the Discover Bank rule, therefore, is to invalidate class arbitration waivers in most consumer contracts, even if traditional factors of unconscionability are absent from that contract formation. The lack of any requirement of showing actual unconscionability meant that Discover Bank case created an essentially categorical requirement of class arbitration. If you're going to want to arbitrate a case, it's got to be the class action case, not one-on-one, not with one consumer, not with one person who has a problem with the thing, right? All right. Requiring class arbitration under these circumstances sacrifices the Federal Arbitration Act, that means goals, of facilitating the prompt and formal resolution of disputes, while also substantially disadvantaging defendants who did not consent to class arbitration in the first instance. The net result of applying Discover Bank is that class arbitration waivers are rarely enforced. Instead, the defendants are required to submit to procedures which they did not consent to and which consumers may be required to participate in, even if the individual arbitration is more favorable. So even if you're going to have to you're an individual trying to arbitrate this, right? The contract is going to force you into a class level arbitration. The class hasn't even been formed or certified yet, so it's a problem, right? Although the majority held in Discovery Bank, the rule was preempted by the Federal Act, it does not follow that the title company contends that all state law unconscionably defenses are preempted by the Federal Act in all cases. For who wrote this? Oh yeah, Titleman wrote this decision. No wonder it's incomprehensible. First, as expressly was stated in Concepcion, was whether California's Discover Bank rule was preempted or whether all state law unconscionability defenses are preempted. Consistent with the state law issue in Concepcion, the Supreme Court held was expressly limiting the finding that California's Discover Bank rule is preempted by the Federal Arbitration Act. Second, the majority specifically acknowledges that this Clause 2 savings permits agreements to arbitrate to be invalidated by a generally applicable contract defense, like fraud, duress, or unconscionability, but not by defenses that apply only to arbitration or that derive their meaning from the fact that an agreement to arbitrate is the issue in front of the court. Finally, the majority opinion discusses in detail the many ways in which the arbitration provisions at issue in Concepcion are fair and reasonable and do not lead to an unconscionable result. This discussion would be superfluous if the majority intended to establish a rule completely preempting all state law as unconscionable. Therefore, the Concepcion majority recognizes that in a case-by-case basis, an approach that provides the appropriate analytical framework for asserting that the applicability of state law of contracts pursuant to Section 2 of the Savings Clause is, quote, an analysis of whether the particular state contract defense is preempted because it stands as an obstacle to the accomplishment of the Act's objectives. Then that depends upon whether or not the federal courts and federal judiciary has a posture, an opinion rendered on that particular case. In his concurring opinion, Justice Clarence Thomas agrees that the Federal Act preempts a state law contract defense rooted in public policy concerns regarding arbitration, even if the policy nominally applies to all other contracts. So there's a provision that's allowed in arbitration contracts that's not the same for all other contracts. Like the majority opinion, Justice Thomas notes that the state law contract defenses, including fraud, duress, and unconscionability, may be applied to invalidate arbitration agreements without contravening Section 2 of the Federal Arbitration Act. But Justice Thomas focuses his analysis on the text of the Section 2 Federal Arbitration Act Savings Clause. The Savings Clause refers only to defenses that result in revocation of a contract and omits any reference to invalidation or non-enforcement of a contract. Thus, he reasons that the Federal Act requires that enforcement of an agreement to arbitrate unless a party successfully asserts a defense concerning the formation of an agreement, emphasis added, contract defenses that are unrelated to the making of the agreement, such as public policy, are not valid grounds for declining to enforce the arbitration agreement. Because the Discover Bank rule relies upon a public policy rationale and does not concern the making of the arbitration agreement, Justice Thomas concludes that the Act requires preemption of the Discover Bank rule and enforcement of the arbitration provision in the ATT General Agreement. After setting out this discussion, Justice Thomas nonetheless concurs in Justice Scalia's opinion because the twin foundations of both analyses are that same. First, the Federal Act does not preempt state law contract defenses pertaining to any formation of a contract. Justice Thomas recognizes this point explicitly, while the majority does so inferentially. The majority holds that the Federal Act preempts Discover Bank because it, quote, stands as an obstacle to the accomplishment of the execution of the full purposes of the objectives of Congress from passing the Federal Act. The application of the Discover Bank rule has nothing to do with contract formation. Consequently, the Supreme Court's preemption of the Discover Bank rule does not preempt all state laws in all instances dealing with contract formation. The second and related proposition, supported by both opinions, is that the Federal Act preemption analysis requires a case-specific assessment of the arbitration contract at issue. The majority opinion holds that state law contract defenses, including unconscionability, are preempted only if state defenses, quote, stand as an obstacle to the accomplishment of the Act's objectives. What you just said above, my God. Titleman, the author of this opinion, is probably being paid by the word that he writes. I'm not sure. Anyways, The question of whether a state law unconscionability defense has an optimal accomplishment of the objective requires analysis of the particular facts of the case. Likewise, Justice Thomas's analysis focused on contract formation defenses like fraud, duress, or unconscionability, which are necessary requisites in the analysis of the facts leading to the alleged formation of the contract. This guy is being paid by the syllable he's writing. Therefore, at a minimum, the rationales of both the majority opinion and Justice Thomas's concurrence permit state courts to apply state law defenses to the formation of the particular contract. Oh my God, people. Oh my God. There is like 4 pages of very dense type pen font saying, if you live in a state that has contractual defenses to it, to a contract, that are part of state law, unconscionability, fraud, inducement, right? Then you can use those state law claims to get out of a contract in your state. If your state does not have those, you can't use those because your state doesn't want those, and there's laws that are passed to give those. That's what you spent 5 pages reading. Moving on. This interpretation is confirmed. Oh, we're confirming it now. Great. It's confirmed by the Supreme Court's holding in Marmet Healthcare Center versus Brown. In Marmet, the state court held that the Federal Arbitration Act, that is, right, does not preempt state public policy against pre-dispute arbitration agreements that apply to personal injury or wrongful death claims against nursing homes. This isn't about that. So take us way back. This claim is about the woman in Missouri who got a title loan on her car for $2,115. The APR on that loan was 300% annually. She made 3 payments the first 3 months she had the loan. She paid $1,000 each month. She paid $1,000 a month on a $2,100 loan. After those 3 payments, the total amount that she owed went down by 6 cents. Not 6%, 6 cents. That's the claim. We're not talking about personal injury. We're not talking about this other crazy stuff. So anyways, we now go down to defenses to contract formation. Talking about unconscionability, fraud, inducement, improper enrichment, fraud, contract defenses, right? Unlike Concepcion, which concern the enforceability of a class waiver, the class action lawsuit waiver, right? In this case, it's whether the arbitration agreement as a whole is unconscionable. The purpose of the unconscionability doctrine is to guard against one-sided contracts, oppression, and unfair surprise. Oppression and unfair surprise can occur during the bargaining process or may become evident later when a dispute or other circumstances invoke the objectively reasonable terms. In either case, the unconscionability is linked inexorably with the process of contract formation because it is at formation that a party is required to agree to the objectively reasonable terms. This guy cannot write. When you make a contract, you have to agree. The person you're making the contract with has to agree. That has to be reasonable, not like hiding the ball, not anything. So all I just said, a whole paragraph. The evidence of this case supports the determination that the agreement's arbitration clause is unconscionable. There is evidence that the entire agreement, including the arbitration clause, was non-negotiable and was difficult for any average consumer to understand, and that the title company was in a superior bargaining position. Remember, if you've been riding motorcycles, doing motorcycle contracts your whole life, and if somebody's like, I've never ridden a motorcycle before, when we make a contract with a motorcycle, right? They are more experienced, more informed, and more informed in their position in bargaining, in negotiating that contract, right? That's what this is saying. There was evidence that the entire agreement was, favored the title company. Brewer could not negotiate the terms of the agreement, including the terms of the arbitration clause. Indeed, the evidence further demonstrated that no consumer has ever successfully renegotiated the terms of a title company's arbitration agreement. This evidence also demonstrated that the terms of the agreement were extremely one-sided. Unlike in Concepcion, where AT&T shouldered the cost of arbitration and would pay double the consumer's attorney's fees if the consumer recovered more than A&T offered to pay in the arbitration agreement. The agreement here, however, provides that parties bear their own costs. So if you're going to arbitrate for this, you have to pay your own attorney's fees. In Concepcion, the arbitration clause waived AT&T's right to seek reimbursement for attorney's fees at all. So AT&T was kind of being a G when they made that arbitration agreement, right? The fact that no consumer has ever arbitrated a claim against the title insurance or the title company, right, under these terms, makes it clear that the agreement stands as a substantial obstacle, not just to arbitration, but also as to the resolution of all the consumer disputes that can ever be leveled against the arbitration or against the title company. The evidence in this case also fundamentally different from the Concepcion case because Brewer, the current case, presents expert testimony from 3 consumer lawyers who testified that it was unlikely that any consumer could ever retain a counsel to pursue an individual claim. There was no such record in Concepcion. A claim such as Brewer's required a significant expertise and significant discovery, and it would not be financially viable for an attorney because of the complicated nature of the case and the small damages at issue, the $2,100 that she got the title loan for, right? The title company presented no contrary evidence from attorneys who said they were willing to take such cases or any pro bono or voluntary basis. So no attorneys are going to help these people out who've been screwed over by title companies. So that puts the title companies in a bad position, right? Oh my God, back to Concepcion. While the majority position in Concepcion makes it clear that the unavailability of counsel is not a sufficient effect by its lonesome to invalidate the requirement of individual conscionability of an arbitration contract, the Discover Bank rule was not preempted because it conditioned the enforceability of an arbitration contract on the availability of an attorney. Instead, the critical flaw leading to the preemption in Discover Bank rule was that it was required of class arbitration disadvantaged consumers, but was unnecessarily for the consumer to obtain a remedy. Discover Bank, therefore, was inconsistent with the core purpose of the Federal Act, which was to ensure the enforcement of private arbitration agreements to promote informal, efficient dispute resolution. Because the purpose of this act is to ensure efficient dispute resolution, the analysis in Concepcion assumes the availability of a practical, viable means of individual dispute resolution through arbitration. In some cases, the availability of counsel, lawyer, right, is relevant consideration for determining whether the act's intent in dispute resolution will be satisfied. As noted above, the totality of Brewer's evidence, including the lack of available counsel, demonstrates there is no practical, viable means of individualized dispute resolution. The title company asserts that the availability of attorney's fees and punitive damages under the state's Merchandising Practices Act negates Brewer's argument that attorneys are unwilling to handle claims such as hers. The title company notes that reported cases indicate that some lawyers are willing to handle cases brought under the Federal Truth in Lending Act for Fair Debt Collection Practices Act, and that those proves that statutory damages provide sufficient financial incentive for attorneys to take the case of such downtrodden folk as Mrs. Brewer. The deficiency in the title company's argument is that it presents a totally theoretical position that attorneys should want to take the cases. Speculation is not a substitute for actual evidence. In this case, there was a specific, uncontradicted evidentiary hearing before the trial court, which demonstrated that the attorneys were unlikely to claim that they would prosecute claims such as Brewer's. Conclusion. The judgment finding the waiver unconscionable is affirmed because the entire arbitration agreement is unconscionable and unenforceable. The judgment is reversed. However, to the extent it severs the class arbitration waiver and requires an arbitrator to determine the propriety of class arbitration, the case is remanded. So she gets to do her thing by herself. Class is settled. This is the longest, stupidest reading in human history. My God. Let's just Titleman learn how to write. Next case. Daddy needs a break. Hang on. Let me find the next case. Okay, cool. We're going to do one more case here. We're going to do Ysbrabnd, Ysbrand, Ysbrabnd versus DaimlerChrysler Corporation. It's a 2003 case from Oklahoma. I need to take a minute. Fix myself. So this is not a U.S. Supreme Court case. This is the Supreme Court of Oklahoma's case, 2003. Ysbrabnd versus DaimlerChrysler Corporation. Moses. All right, let's do this thing. Judge Hodges is writing the opinion. This opinion reviews the trial court's determination that the dispute meets the requirements for a class action found at Title 12, Section 2023 of the Oklahoma statute. The class certification order is affirmed as to the warranty of claims asserted, but is reversed for the claims of fraud and deceit. So basically, there's a warranty claim. Supreme Court says yes. Supreme Court of Oklahoma, that is, says yes. The claims against fraud and deceit reversed. Defendant is DaimlerChrysler, a Delaware corporation with its principal place of business in Michigan. It manufactured over 1 million 1996 and 1997 model minivans equipped with a front passenger seat airbag. Plaintiffs are each the owners of one of those minivans and have asserted a Uniform Commercial Code UCC claim for a breach of express warranty, breach of implied warranty of merchantability, and breach of implied warranty of fitness. In addition, they assert further claims for fraud and deceit. Plaintiffs' claims are based on their assertion that the front passenger seat airbags are defective due to 1, their propensity to over-deploy with aggressive force, and 2, that's not good, and their propensity to deploy during a low-speed collision. Oh, we've heard about this case, right? You're like knocking, like a shopping cart hits your minivan, and the airbags deploy and snaps your child's neck, or like gives you a concussion, even though a shopping cart touched the front of your car. That's what we're talking about. Plaintiffs further assert that DaimlerChrysler failed to warn purchasers of this defect and that the defect has the potential to kill or seriously injure a child or a small adult seated in a front passenger seat. According to the plaintiffs, there are airbags available which deploy with less force and at higher collision speeds. The claim that these bags are currently used as replacements when the bag has been deployed. Plaintiffs seek damages in the amount sufficient to allow the owners to install the new, safer airbags, or in the alternative, to replace any defective airbags that were made by DaimlerChrysler. Following the initial discovery and hearings, the trial court issued a 21-page order certifying a class action considering the owners who are current owners of minivans at issue to be excluded, both owners who have suffered, so everybody who owns a minivan, you can be part of it. But anybody who suffered an injury personally or who have minor children suffering injuries from them are excluded from that because they're a separate class who are injured differently. There's more damages for their part, right? DaimlerChrysler now appeals the class certification order. Class certification action is a procedural device by Title 12, Section 2023 of Oklahoma statute. It prevents plaintiffs to, quote, vindicate the rights of individuals who otherwise might not consider it worth the candle to embark on litigation in which the optimum result might be more than the consumed by the cost of the litigation, close quote. Section 2023 requires, as does the federal counterpart, numerosity, commonality, typicality, and adequacy of the representation to certify a class. In addition, the court must find that, quote, questions in law or fact common to the members of that class predominate over any questions attaining to only individual members, and that a class action is superior to any other individual means of representation or of remedy for those members who were hurt more than others, right? DaimlerChrysler challenges the trial court's determination that each of these requirements has been demonstrated by the plaintiffs. Its challenges focus primarily on whether the common questions of law and fact predominate and whether a class action is superior to any other available mechanism or method of adjudicating the controversy. 1. Common issues of law or fact. 1. Issues of law. A. DaimlerChrysler argues that the common issues of law or fact do not predominate because varying state laws will apply to the asserted claims and defenses. It cites a Oklahoma Supreme Court 2000 decision called KMC Leasing versus Walkwell Standard Corporation, in which the Oklahoma Supreme Court found that no abuse of discretion in the trial court's refusal to certify a class for lacking predominant issues. The proposed class consisted of private aircraft owners who alleged that 4 different product defects against multiple defendants in different states. The matter required the application of differing terms in hundreds of non-uniform aircraft purchasing contracts. Because the substantive law of numerous states applied to issues which were not common to the entire class, not all the aircraft owners had the same issues, they're not going to make them a class action. And the court did not err in saying, we're not going to make you all idiots a class action. In the matter, the trial court determined that, quote, the alleged choice of law problems identified in DaimlerChrysler did not bar a class certification. It relied upon a case called Bridgestone v. Firestone Incorporated Tires Liability Litigation, a federal Second Circuit court from South Dakota, which granted a class certification on finding a predominance of issues applied to all the people who purchased those tires. In the Firestone case, the district court was sitting in Indiana and determined that all the states who were part of this as substantive law applied to a nationwide state class action. Buyers had asserted tort and contract claims against Ford Motor Company and Bridgestone for alleged tire defects in the Ford Explorer's model sport utility vehicle. The court reasoned that because the relationship between the parties was simply that of buyer and seller, the place where the products were purchased was not significant to the claims of product defects. Rather, it was, quote, the conduct of the defendants as the manufacturers, end quote, which was the focus of litigation. Therefore, the laws of Michigan and Tennessee, which were the principal places where the people who were filing suits could apply equally to both of the lawsuits. The trial court's application of Firestone to this matter evidences its intent to apply the substantive law of Michigan, DaimlerChrysler's principal place of business, to the claims of the defenses asserted. Application of Oklahoma's choice of law rules supports that conclusion. One, choice of law, UCC, Uniform Commercial Code claims. The, quote, most significant relationship test applies to an action for breach of warranty in the sale of goods under Article 2 of the UCC. This test is guided by principles and contacts with the restatement second of conflicts. It determines which state law is the most directly connected to the parties of the transaction. Under Section 6 of the restatement, the factors relevant to any choice of law decision include A, the needs of the interstate and international systems, B, the relevant policies of the forum, C, the relevant policy of other interested states, and the relative interest of those states in the determination of the particular issue, D, the protection of justified expectations, E, the basic policies underlying the particular field of law, F, certainty, predictability, and uniformity of result, and G, ease in determination and application of law to be applied. The contacts to be considered in applying these principles to an issue in the contract include A, the place of contracting, B, the place of negotiation of the contract, C, the place of performance, D, the location of the subject matter of the contract, E, the domicile, residence, nationality, place of incorporation, and place of business of the parties. The contracts are to be evaluated according to their relative importance with respect to the particular issue at hand. However, there's a third provision, Section 191, which applies a sales of interest in chattel, which says, quote, so in a contract for the sale of goods, the most significant contact is the place of delivery, unless another state or more significant place has a relationship. The comment to F of Section 191 says, quote, on occasion, a state which is not the place of delivery will nonetheless, with respect to a particular issue, be the state of most significant relationship to the transaction, and the parties to the chattel, and hence, therefore, the state of the applicable law, close quote. The particular dispute in this matter presents such an occasion which, quote, the local law of some state other than that of delivery should be applied in any event because of the intensity of the interest of that state in the determination of this particular issue, close quote. All 50 states, as well as the District of Columbia, bear some relationship with the parties and transactions in this dispute by virtue of the nationwide sales of Chrysler-Daimler minivans. The question becomes whether the relationship of each state where the vehicles were purchased is more significant to the parties and to this litigation than that of Michigan, the principal place where DaimlerChrysler is incorporated and does it, well, not incorporated, it's incorporated in Delaware, to where it does its business. Restatement section 188, subsection 2 says, contacts for the purpose and place of contracting, the place of negotiation and performance, and the location of the subject matter are of diminished significance to the sales of minivans. The UCC warranties are not something that was negotiated by the purchaser of a new car, thus the relative interest of each buyer's home state in applying its version of the UCC is more or less equal. By contrast, Michigan's interest in having this regulatory scheme applied to the conduct of a Michigan manufacturer is the most significant thing. Michigan is where the decisions concerning the design, manufacture, distribution of the minivans were made. Michigan is the only state where the conduct relevant to all class members has occurred. That's important. The principal place of DaimlerChrysler's business operations is most important contact with regards to UCC, and that is Michigan. The selection of Michigan law further reveals the relevant factors stated in Section 6 of the Restatement of Conflicts. The need for the interstate system, the basic policies, predictability, and uniformity is all required that the result of a particular product defect be determined in one form with the result, rather than all 51 form in jurisdictions with the very possible reality of conflicting decisions. With the interest of each home state in applying its local law is significant, Michigan's interest in the conduct of its manufacturers and therefore the connection to warranty issues is greater. So Michigan law applies. It should be noted that the conclusion is consistent with the constitutional imperative that, quote, for a state substantive law to be selected in constitutionally permissible manner, that state must have a significant aggregation of contacts, creating state interest, such that the state choice of law is neither arbitrary nor ever fundamentally unfair, citing from the Hague Convention, Supra, page 297. So, now we're on to choice of law for the fraud and misrepresentation. We're getting to the end, folks. We have a little bit left. Section 148 of the Restatement footnote 6, or Restatement 2 of conflicts of law, applies to actions to recover pecuniary, that means money, damages for false representations, whether they are fraudulent, negligent, or innocent. Section 2 applies to this dispute because there is a nationwide representation in DaimlerChrysler's advertising that were made in states outside of each of the class member in this class action lawsuit's home state. The home state is where each class member acts in reliance on those representations by purchasing a minivan. Thus, the court is directed to consider, quote, A, the place or places where a plaintiff acted in reliance upon defendant's fraudulent representations. B, the place where the plaintiff received the representations. C, the place where the defendant made the representations. D, the domicile, residence, nationality, place of incorporation, or place of business of all the parties. E, the place where a tangible thing which is subject to the transaction between the parties was situated at the time the transaction occurred. And F, the place where the plaintiff is to render performance under a contract which he has been induced to by either a false representation or a fraud of the defendant. The comments of subsection 2 describe A, B, C, D, and E as, quote, more important of those contacts. Comment J now articulates a general approach, quoting comment J to section 148, subsection 2, mini A. This is comment J to that. If any two of the above-mentioned contacts appear for the defendant's place of business, and they are located wholly within a single state, this will usually be the state of the applicable law with respect to most issues. So when a plaintiff acted in reliance upon a defendant's representation in a single state, this state will usually be the state of the applicable law with respect to most issues. if A, the defendant representations were received by the plaintiff in that state, and B, that is the state where the plaintiff was domiciled, where they lived. In this matter, each class member presumably received the representation in their home state, which is their place of domicile. Therefore, the contacts point to each class member's home state and their applicable law. Applying the law of 51 jurisdictions, the fraud claim presents an overwhelming burden with which would make the class unimaginably unmanageable, and a class action determination of that claim inappropriate. The class action certification by the trial court will go forward only on the warranty claims in Michigan as asserted. B. Issues of fact. The court concluded the individualized issues of fact were minimal and did not appear to find a defeat of the finding of the predominant, basically the lower court, the fucking airbag sucked. There you go. These casebooks suck. That's what it is. So they're not going to certify the case for the fraud claims, but for the misrepresentation claims, they will certify the case as long as it's only people who live in Michigan, who bought the car in Michigan, or who lived in Michigan when they saw the advertisement for the minivan in Michigan. Conflict of law, folks. It's a whole thing. Take good care. Good night. Have a great weekend. Tip your bartenders, tip your waitresses, tip your wife. Give everybody you love a hug, and have a great evening.